Welcome back for part two. Part two of this habeas corpus. I'm going to start off with the pagan house of worship. Many of y'all have heard me talk about how I dealt with the court, breaking out the pagan house of worship. So I'm going to do this, and this can be a little more informative than the way I put it. This title of this section is Pagan House of Worship, that the jurisdiction of a military admiralty jurisdiction in maritime law in Hickman County, because that's where we were at, is a pagan temple of worship. Okay? Now here's the definition of temple. Temple, 1A, a building dedicated to religious ceremonies or worship. Either of two successive buildings in ancient Jerusalem serving as the primary center for Jewish worship. 2, something as having with it a divine presence. A building used for meeting by a fraternal order. A building reserved for a highly valued function. Either of two groups, this is 5, either of two groups of buildings in London. The inner temple and the middle temple that houses 2 of the 4 inns of court and occupy the site of medieval Knights Templar establishment. 6, a building of imposing size, etc., serving the public or an organization in some special way. A temple of art, a Masonic temple. Also relevant is inns of courts, the 4 legal societies in London having the exclusive right to admit persons to practice at the bar. 4 groups of buildings, Gray's Inn, Lincoln's Inn, Inner Temple, and Middle Temple belonging to these societies. Okay? That's temple. So, pagan temple of worship. In your military tribunal, which is a pagan house of worship, the judge is a minister who serves Lady Justice. Lady Justice is a Roman pagan goddess. Justitia's counterpart was a Greek goddess named Dike. Her temple was on the Greek island of Lesbos. The priests burnt offerings 24/7 and had white robes that stayed black with soot. After some time, the priest changed to black to hide the soot. They changed their robes from white to black so they could hide the soot. The judges used to wear white robes, but later switched to black robes. Hence, black robes, white justice. The goddess with the scale goes even further back than Dike. In the Egyptian Book of the Dead, there is a human goddess by the name of Maat. She weighs the heart against a peacock feather, and if the heart was heavier than the feather, a half man, half crocodile would eat your heart, and you would not go in to the afterlife. Tennessee Constitution, okay? Listen to how this reads. It reads, I believe it's Article 1, Section 3 of the Tennessee Constitution, and it reads that all men have the natural and indefeasible right to worship Almighty God according to the dictates of their own conscience. that no man can of right be compelled to attend, erect, or support any place of worship, or to maintain any minister against his consent, that no human authority can in any case whatever control or interfere with the rights of conscience, and that no preference shall ever be given by law to any religious establishment or mode of worship. Any judge that administers justice is an administrator. If one looks up administrator in Webster's dictionary, it will say see minister. Okay? That pretty much explains it. You can't be forced to attend, erect, or support any place of worship according to the dictates of your conscience. That means if they can say it till they're blue in the face and the cows come home. We're not a pagan temple of worship. It doesn't matter. If my conscience dictates that it is, then it is. And you'll find that in every constitution, every one that I've ever read. I haven't read them all, but I've read most of y'all states' constitutions. And a lot of them are the same. And you will always see something in every one about the rights of conscience. You have the right to decide what is what, how you see things. If my conscience dictates that there are only two genders, then guess what? There's only two genders. You can cry all you want about all the different things and the pronouns and all that crap. You can cry all you want. But according to the dictates of my conscience, there are only two sexes, male and female. But I'll get off on that because I want to stay focused on this. Many cases define the courts as a temple of justice. Our justice system, this is a court case. This is a quote from a court case. Our justice system would crumble should those whose hands are entrusted its preservation and sanctity betray its fundamental values and principles. That's Monroe versus California, 1995. And citing section 6068 and referring to a court as temples of justice. See also 550 Federal Supplement 1317, which states the citizenry is raising up to destroy the temples of justice. That's what we're doing, folks. The Act of 1833. In every point of view in which this question has been presented to my mind, my clear convictions are that the Act of 1833 is not consistent with any obligation which Tennessee is under to the federal government. Tennessee, by its passage, has violated no right ever recognized in the Indian tribes. That's what this was. It was an Indian, the native indigenous people question. The right of property, both real and personal, and their full, ample enjoyment is secured and protected. No pledge on the part of the state has been forfeited. Tennessee only asserts the privilege of punishing for the commission of crimes the most shocking to our nature when committed with sight of her temples of justice. She cannot consent to see her citizens and others robbed and murdered, whilst the robbers and murderers laugh and scorn the power of her laws. A lot of he's, she's in there, isn't it? Hers. I, Christopher-Alan Hauser, attest that I was not afforded the opportunity to be brought forth into an Article 3 court. Article 3, Section 1 states, the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme Court and inferior courts shall hold their office during good behavior, and shall at stated times receive for their services compensation which shall not be diminished during the continuance in office. That's every judge should not be paying taxes. If they were all Article 3 courts, these judges wouldn't be paying taxes at all. No state taxes, no income taxes, no property taxes. They shouldn't be paying none of that. But they do, which means they're not Article 3 courts. You never have your day in court. Only United States Supreme Court is an Article 3 court. I wrote this. You guys got to remember, I wrote this about 4 years ago. Which by the Constitution is the only court that is lawful. West Tennessee Code Annotated Constitution of the State of Tennessee, Article 1, Declaration of Rights. The inferior court, which is a military admiralty tribunal, did not have jurisdiction as your military court and pagan house of worship, violated my rights under Article 1, Section 14, 114, 215, 316, 617, 818, 1019, and 1520 of the Tennessee Code Annotated Constitution of the State of Tennessee. Okay, now I want to get into this right here. That's addressing it a couple of ways. What's the issue here? What is it that is the reason you don't have power over me? Well, we're going to get into some stuff as this goes along. This is sovereignty established. Sovereignty defined. The sovereign is a non-juristic human being that is a member of we the people. All sovereign rights come from God, not the state. The sovereign does not qualify as a person as defined by statute laws. The sovereign is independent, self-governing, and lawful. The term sovereign, and to this particular extent, means property herein, being the Christopher-Alan Hauser, comma, the human, comma, the beneficiary and sovereign body, mind, and all of his material possessions and ownership thereof, and further illustrates that the people of the state are entitled to all rights which formerly belonged to the king at his prerogative. See Lanning versus Smith, New York, Southern Court, 1829. Right? The people of the state are entitled to all rights which formerly belonged to the king, King George, at his prerogative. Okay? You got the rights. You are a king. You have the rights of a king. That's why they're not charging you. They're not charging the sovereign. A lot of times when people go into court, the judge will go, "Are you a sovereign? Are you a sovereign citizen?" If you say yeah, you're cutting your own throat. I would point at him and I'd say, no, you're a sovereign citizen. You're a citizen or a subject while you sit up there wearing your hat and your black robe. You're a sovereign when you take that robe off and you go home to be with your family. The castle rule. The cop is a subject or a citizen while he's wearing his uniform and he has his badge on. But when he goes home, he's the king of his castle. That's proof there enough that they're the sovereign citizen. Me, I'm just sovereign. I'm just sovereign. I'm not a subject of anything worldly. Then on page 17, the bottom of 17, the footnotes, there's doctrine of non-resistance. The government being instituted for the common benefit, the doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. You must resist. Freedom of worship. Trial by jury or jurors. Deprivation of life, liberty, and property under law, due process. Double jeopardy, habeas corpus. These are all things that I bring out and note. Oh yeah, let me do this. See United States versus Lee, 1959, meaning American citizens upon the soil. Furtherance, the United States Supreme Court recognizes three different sovereigns. The United States as the federal government, that's a sovereign. The state governments, right, that's a sovereign. And we the people. And stated that while sovereign powers are delegated to the government, while sovereignty itself remains with the people. See Kansas versus Colorado. That's two states going after it. Claimant at law attests that the sovereign, we the people, cannot be named merely as a person or any person in statute, but must be specifically specified within the language of the statute. In addressing this issue, the Supreme Court stated that the term person does not include sovereign. And for the sovereign to be bound to the statute, the sovereign must be specifically named. Go in there. No. If you're charging me like you're saying you've been charged. Well, then change that up there to the sovereign's name. Let's identify who's actually being charged here. Are you charging the sovereign? Are you charging the sovereign? Because the Supreme Court says that you have to be specifically named. In common usage, the term person does not include sovereign. And statutes employing the word are ordinarily construed to exclude it. So when you read all the different definitions of what a person is, it excludes the sovereign. That's Will versus Michigan State Department of State Police. 1989. And Wilson versus Omaha Indian Tribe. U.S. versus Cooper Corporation, and U.S. versus United Mine Workers, right? Subject matter. Subject matter jurisdiction is invoked when you're doing one of these. You're invoking subject matter jurisdiction. The claimant at law, a sovereign, invokes the subject matter jurisdiction of the Constitution of the United States for the United States of America. 1789, by my private authority in accordance with Article 10 of the Bill of Rights, right? Article 10 says, whatever's not delegated to you and to the state remains with the people. Okay? For example, John H. Alden et al., Petitioners versus Maine. The court stated that, in view of the 10th Amendment's reminder that powers not delegated to the federal government nor prohibited to the states are reserved to the state or to the people, the existence of the expressed limitations on state sovereignty may equally imply that caution should be exercised before concluding that unstated limitation on state power were intended by the framers. Okay? Claimant at law invokes sovereign immunity. In accordance with the Foreign Sovereign Immunities Act of October 21st, 1976, Public Law 94-583, 94th Congress, 90th Statute at Large, Sections 1 and 15, Statutes at Large, Chapter 149 through 25, there's a page description of 1999. Title 8, the United States Code, subsection 1481, is still in full force and effective to this date. Nothing in the International Covenant of Civil and Political Rights herein, ICCPR, 102nd Congress, Second Session, Executive 103 through 2023, January 1992, requires legislation and other acts by the United States of America prohibited by the Constitution of the Constitution for the United States of America, as interpreted by the United States. See ICCPR, page 24. This means that the restrictions of the Constitution will come into effect when they are applied by sovereign American of one of the several compact states of the Union, and everything that state agents, actors, officers, employees, or elected officials attempt to do to a sovereign American with presentments, i.e. attached information, initial, affidavit of probable cause, statement of facts, amended information, primary and secondary, judgment and sentencing, and warrant commitment is null and void. Duty of the court. It is the duty of this court to act upon common law writ of habeas corpus, writ of injunction by a person in state custody. Because see, what you're doing when you say, how is he saying that he's not a person? And then he puts this in here, person in state custody. Because your person is in state custody. When your person is released from state custody, they cannot contain the natural human, the natural being. That natural being's held as collateral along with the person in a court of law within an Article 3 of the Constitution of the United States. America, judges' compensation has not been diminished during their continuance in office. Since it originated in this court, and it should have recognized the state and federal constitutional violations that occurred, and that have been presented herein, we are allowed, and were allowed to occur either through neglect, mistake, inadvertence to this sovereign claimant at law's detriment. Furthermore, it is well within the court's authority to make right that which is wrong. All judges are bound to comply to the Tennessee State Constitution as well as the Constitution for the United States of America and all the treaties entered into which each state has followed. This Constitution and the laws of the United States, which shall be made in pursuant thereof, and all the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound therein. And things or anything is the Constitution or laws of any state to the contrary notwithstanding. See U.S. Constitution, Article 4 or Article 6, Clause 2. Therefore, the state may not, in the name of local control over local laws and practice, give state courts the power to violate the supreme law of the land. See Kalb versus Fierstein, 308 U.S. 433, 439, 1940. The judgment of conviction are or is void in abnito. In abnito means from the beginning. They're void from the beginning. It goes on to talk about how they're void. In the ICCPR, it explains how they're void and how they've been voided and nulled. And this is explaining 20 at the bottom of 21 how they're void from the beginning. It mentions, it really gets into how we were doing the FOIA and the taxes at the 1099. Let me see if I can pull some of these numbers. The 1099 OID, the 1096, and the 1040, and how we went about all of that. We're going through the office's management and budget, and let's see, the penal bonds at the OMB, number 9000-0045, standard form 2425, 25A, 273, 274, and 275. Bid performance payment bonds, reassurance agreement for a Miller Act performance payment in favor of the United States bonds. That's what these next few pages are involving. You may not need to, you could probably go through that and strike a lot of that stuff out. There's a lot of references to the UCC, what the UCC is saying, how it's a common law contract through the postal rule. And the tax issues involved. And then part 2 of this document is the state of Tennessee has no subject matter jurisdiction to further hold the claimant at law in custody of the Department of Corrections. And the claimant at law attests that because his eligible issue, or the 1099 OID regarding all penal bonds, were returned to the source and closed of escrow exchange, and the closing of the escrow exchange was fully settled. The judgments are void and on its face and without any legal effect or authority. Has no jurisdiction of the subject matter to further hold the claimant at law in custody of the Department of Corrections, and must issue an immediate court order releasing from custody. Subject matter jurisdiction over the nature of the case and type of relief sought, and to the extent in which the court can rule on the conduct of persons or the status of things. See Black Law Dictionary, 8th edition, 2004. A judgment would be a nullity if the judge has no jurisdiction of the matter, referring to subject matter jurisdiction. See subject matter, the cause, the object, and the thing in dispute. It is a fatal objection to the jurisdiction that the court, when it has no cognizance of the subject matter jurisdiction of the action, if a cause exclusively of admiralty jurisdiction were brought into a court of common law, or vice versa, or a criminal proceeding in a court having jurisdiction over civil cases only, or vice versa. In such cases, neither a plea to the jurisdiction nor any other plea would be required to oust the court subject matter jurisdiction. Therefore, the cause can be dismissed upon motion. Common law Article 3, writ of habeas corpus by the court, ex officio. That's from the office. That's what that means. Powers may be exercised by an officer which are not specifically conferred upon him, but are necessarily implied in his office. These are ex officio. Thus, a judge has ex officio when the powers of the conservator of his peace. Courts are bound to notice public statutes judicially and ex officio. King versus Physicians Casualty Association of America, and that's Nebraska. Lebrango versus Police Jury of Parish in Plaquemines, Louisiana, and Ayland versus Mercer County, Kentucky, is what that's. And you can see Bovier's Law Dictionary, 6th edition, 1856. It's apparent here by its definition of subject matter, such jurisdiction limits the court's authority of subject matter, that a criminal nature to be a criminal court, and subject matter that is civil in nature to be the circuit or chancellery court. The claimant at law attests that the generating of these prepaid penal bonds, Form 24, 25, 25A, 273, 274, and 275, bid bonds, performance bonds, payment, reassurance agreement for a Miller Act performance, etc., are a product of the criminal statutes in exchange for conviction of the legal artificial fiction trust entity, all caps, letters, designation, Sestake Trust, that was convicted of, in whatever the crimes, in which the living human being and sovereign claimant of law is illegally imprisoned as the fictional or artificial Sestake Trust name above. Furthermore, the Tennessee courts have declared and acknowledged the existence of the fiction artificial entity in your own case law in NBMA America NA versus Michael J. DeRocha, 2007. And this is Tennessee Court of Appeals, November 19th, 2007. Bank of America NA. When the court found that Michael J. DeRocha and Michael J. DeRocha, all caps, are separate entities. The Tennessee Court of Appeals has the name where the court found that Michael, capital H, the rest of them lowercase, capital J period, capital D, the rest of his name in lowercase, and Michael J. DeRocha, all caps, are separate entities. They're even saying it. The claimant at law also attests that the use of penal bonds, bills, or true bill indictments, essentially commercial instruments, that is being generated off the credit of the accused convicted, i.e. his fiction, artificial Sestake Trust, are products of the criminal statute that in reality are commercial crimes, making this a civil matter than a criminal. Based on the above facts, this case is entirely a civil matter, i.e. under commercial crimes, and that the blank county criminal court has no subject matter jurisdiction to adjudicate and render judgment of a civil matter in a criminal court jurisdiction. He just proved that. This is proof that it's a civil matter because they're commercial, and they're not after the being. And it's in a so-called criminal court that they're doing this. That's where they lack the subject matter jurisdiction. For the record, be it known that there is a presumption with respect to the facts related to subject matter jurisdiction and the penal bonds, which provides that such fact or facts is presumed, and before the tier of facts can find the existence of this or these fact or facts, i.e. the penal bonds, the trespasser has the burden to introduce evidence that supports a finding of its non-existence. See Uniform Commercial Code 1-206. Because all these prepaid penal bonds are a product of the criminal statutes that we returned to the source, and that the closing of the escrow exchange were fully settled, the judgments are void on its face, and is without any legal effect or authority. And because the state of Tennessee no longer has subject matter to further hold the claimant at law in custody of the Department of Corrections for the crimes that are alleged in the indictment, this or that is essentially a commercial instrument, which are commercial crimes that must be adjudicated in the civil court jurisdiction. Therefore, the judgment of conviction must be vacated and dismissed, and the claimant at law is immediately released and discharged from the TDOC custody. The next video I make will start out with, the court must vacate, void judgment, the court shall take notice. And that'll start on page 31, y'all. All right. I don't know if I'll finish that one tonight because it's getting a little late, but I'll be on it pretty soon in the next couple of days anyway. Peace, y'all.